So welcome.
Oh, there you go. That worked.
Welcome to all of you, and welcome to especially Professor Alison LaCroix from the University of Chicago, our featured guest tonight, but also welcome to everyone here. This is an annual event in the Constitutional Law Center that we call the Publius Symposium, after the most famous book in the founding period. Each year we honor a recently published book in the field of constitutional law, very generally defined. And this is about the fifth or sixth year that we've been doing this. And for this year, it's a real pleasure to welcome Alison LaCroix, who's going to be talking about her really fascinating book about the antebellum developments in antebellum constitutional law. This antebellum being roughly between the War of 1812 and the Civil War. And when I say it's fascinating, I'm not just saying for constitutional law nerds, although they may be the large majority in a gathering like this, but wonderful stories, really interesting insights into the way a law evolves. And so I recommend it to you. It is not quite out, but will be how soon?
Spring of 2024.
Oh my goodness, I thought it was sooner than that.
It was, but presses have supply chain issues too.
Okay, well, so it will not quite be out in time to give it as a Christmas present to all your loved ones. But in any event, the way we're going to proceed is that Alison is going to give us some observations about the project. And then the three of us are going to each offer, about 5 or 10 minutes of commentary. And the hope is that we'll have time for questions and comments from the floor. So let's get going.
Great. I'm going to stay seated. Well, I'm delighted to be here with you today. And I'm deeply honored to have my forthcoming book as the focus of the Publius Symposium this year. So let me begin by offering thanks. First to Michael McConnell for the gracious invitation to be here today, and then to Greg Oblowski and Ann Twitty for reading the book and commenting on it, and others in the room who have been invaluable interlocutors along the way. I see a few: Jonathan Knapp, Amalia Kessler, and others. And then I'd also like to thank Morgan Whelan and Rebecca Talbot, the Executive Director and Acting Executive Director of the Constitutional Law Center, for their work in organizing this event and everything leading up to it. So in these brief remarks, I'll begin by sketching the book's central argument and its main themes, and then I'll move to discussing a set of core episodes, a sort of set of events in the moments of the book that I think are really at the heart. They're actually in the geographic center in the overall map of the chapters, and they're also at the substantive and methodological nucleus of the body of the book itself. So first I'll begin with the argument. What is this book about, you might ask? And what do I mean by this phrase, the Interbellum Constitution? Well, the subject of the book is the nature of the American Union between 1815 and 1861, a 46-year period that was bordered on both sides by war, hence interbellum, the War of 1812, which ended in 1815, and the Civil War, which began in 1861. And I argue that we must change our view of these decades, in particular of the legal and political debates that took place within them. And the book offers a new framework for thinking about this period. In arguing for the significance of this period and of the Interbellum Constitution, the book makes 5 principal arguments. I was thinking of them as I wrote. I thought of them as the maxims, not because I set out to produce maxims, but just when you're writing a book, you kind of need these anchoring points. And so the first of these, I'll call them principal arguments, you don't have to call them maxims, is this idea that the interbellum debates constituted a distinct period, that the interbellum period was something different from what came before and what came after. For too long, I think the early 19th century has sometimes been treated as simply a gap or a hiatus between the real show, especially among constitutional law scholars, the founding era on one end and Reconstruction on the other end. And this is the kind of intermission. And I argue instead the period's best understood as the era of the Interbellum Constitution. So what was the Interbellum Constitution? Well, I argue it's a set of widely shared legal and political principles combined with a thoroughgoing commitment to the idea that those principles gained meaning through debate. They were not fixed. The shared principles were commerce, concurrent power, and jurisdictional multiplicity, all of which were frequently grouped by contemporaries under a heading of commercial union. So you find people talking about commercial union quite a bit. And these debates took place in lots of different arenas: newspapers, pamphlets, private letters, legislative chambers, and of course the courtroom, including the arguments of lawyers as well as the arguments of judges. The book's focus is constitutional and political debates about what we would now call federalism, but that word doesn't accurately capture what I'm calling the landscape of constitutional discourse in this early 19th century period. Here's where the second and third of the book's arguments become relevant. The book is rejecting two conventional stories about federalism debates in this period. One of them is what we might call the binary federalism account, which frames all disputes about federalism as about the states versus the federal government. Every argument about union is really about the states and the federal government in opposition to each other. The other conventional account follows from this, and it's a kind of valence question, the valence of each power in the federal-state dyad. According to this view, the federal power tends toward liberty and freedom, and state power, meanwhile, in many different incarnations, tends toward, and perhaps is even necessarily tied to, protections for instance, slavery and limits on freedom. And the era has typically been viewed through this antithesis lens, and indeed as a preview, a kind of runway to the Civil War. So the lens of the impending crisis and irrepressible conflict and everything that followed the Civil War, which I think gets cast back on this period as, well, inevitably it was about federal versus state, and inevitably, or kind of naturally, federal was emancipatory and liberatory, and state, whenever people talk about state, they're using it in some way to mean the opposite of this. As the book demonstrates, however, the valence of federal power in the interbellum period did not necessarily orient toward freedom in all cases, and the embrace of state authority did not always serve subordination. Third, the book argues that ideas of concurrent power were uniquely central to interbellum constitutional discourse. So this is a kind of corrective I'm offering to the binary idea. And this embrace of concurrence set the period apart from both the founding era and the post-Civil War regime. Concurrent power was one of the things left unspecified or underspecified by the Constitution of 1787. Were the enumerated powers of Congress exclusive, especially the commerce power? This was something that was unsettled at the founding and actually remained unsettled, or if anything, tilted toward exclusive federal power through much of the interbellum period. And early 19th century Americans were really consumed by these arguments about concurrent power. After 1815, many of the most pressing legal and political questions concerned areas in which concurrent power was plausible, including commerce, migration, and slavery, some of the key constitutional, legal, and political issues of this period. Importantly, arguments for concurrent power in this period were not necessarily the same thing as arguments for state power. Sometimes, yes, but often it was an actual distinct realm. The fourth claim the book makes concerns a core element of modern constitutional law, the federal commerce power. In practical terms, commerce was the primary crucible in which these interbellum battles over what we can call federalism for purposes of conversation boiled. In terms of constitutional structure, the commerce clauses of Article 1 were really the doctrinal vessels into which these conflicts were poured. So it's not a coincidence that you find the first Commerce Clause case in the Supreme Court happening in this period, and some percolation, as I'll talk about the commerce power in the lower federal courts also in this period. It was all part of this burst of intellectual ferment and conflict over the nature and scope of Congress's power to regulate commerce among the states, commerce with foreign nations, and commerce with native nations. The fifth claim concerns union, one of the most amorphous, important, underspecified terms of this period. Both the sense of the union meaning the American Federal Republic, and union in a more general and theoretical sense. The book highlights the many and varied meanings of the concept of union in this period, which were also contested. Sometimes contemporary commentators invoked a substantive vision of union. For example, the argument that the commerce power, the interstate commerce power, was a tool to foster the commerce of the union, which was central to many of the lawyers' arguments and the Supreme Court's decision in Gibbons versus Ogden, the seminal commerce power case. Sometimes theorists called upon union as a talisman of unity and national purpose to rebut claims of local power and particular power. In other instances, union was more of a stand-in notion, an agreement to defer difficult political questions or political choices, sometimes in the name of compromise. So this is Daniel Webster's second reply to Hayne. This, at some level, is Lincoln's first inaugural. And so the use of union as a kind of agreed-upon concept that in some ways submerged or set aside the more difficult substantive questions. By the 1850s, though, the last chapter or two of the book, critics of the rhetoric of union were demanding more. They were criticizing this thin version of union and the purpose of the union. So we see this in debates about the Fugitive Slave Clause and the Fugitive Slave Act of 1850 in particular. And many people in the period began expressing dissatisfaction with what they regarded as tautological views that assumed the union existed, assumed it could be maintained, and that it was worth preserving, when the emotional and moral and constitutional heft of the phrase the union was, like so much else in this period, contested and fragile. But again, if you read the Civil War and the post-Civil War era backwards, the union looks quite different from what union was being used to mean by many in these debates. Amid these upheavals, I think of interbellum Americans as adolescents par excellence. They have an adolescent mix of bravado and anxiety. You never quite know which one you're going to get in any given moment. They sometimes viewed themselves as cast adrift when the members of the founding generation died in the 1820s and 1830s. At the same time, interbellum legal thinkers were enormously creative. They weren't the passive heirs of the founding, nor were they mere implementers of an already fixed constitutional meaning. They weren't just putting it into practice, making it work. This certainly, this creativity becomes apparent when we expand our study of interlocutors beyond the usual candidates. And in the book, I tried to think of the people I was talking about and analyzing as producers of constitutional discourse, which is more capacious than lawyers, judges, and statecrafters. It includes other people. These thinkers believed that duty required them to be faithful heirs of the founding. So, for instance, Abraham Lincoln, in his 1838 Lyceum address in Springfield, Illinois, called for the political religion of the nation to be extended, and he meant reverence for especially the Constitution and the Declaration of Independence, the founding charters. So these thinkers believed in that duty, but they also appeared not to feel confined by the actual text of the Constitution. So here are some of the producers of constitutional discourse in the book. William Wirt, who was the Attorney General, Maria Henrietta Pinckney, Frederick Douglass, John Marshall, John Ross, Elias Boudinot, Daniel Webster, William Johnson, John C. Calhoun, many others, producers of constitutional discourse who understood themselves as obliged to honor the structure of the Constitution, but really committed to constitutional interpretation as an ongoing project. So with that, I'd like to turn to a core episode, as I think of it, a set of core episodes in the book concerning South Carolina in the 1820s and 30s. But this isn't the usual South Carolina of the 1820s and 30s. I'm teaching both federal courts and American legal history this quarter. Yes, we have quarters too. And every time you say the 1830s and the nullification, and people, well, not in American legal history because people know what they're getting into there, but there's a sort of sense of we know what these stories will be about. But the episodes I'm interested in concern two searing moments of legal and political controversy, and yes, they focus on Charleston, but they are not exactly the nullification debate and the nullification crisis, and they do not have John C. Calhoun at their center. He's a sort of peripheral figure. So these episodes involve a pair of leading, but for different reasons, largely forgotten or ignored Charlestonians. One of them is William Johnson, Jr., a Supreme Court justice from 1804 until his death in 1834, nominated by Thomas Jefferson to be a Republican bulwark against John Marshall, because Jefferson knew someone has to stop these unanimous opinions. You can live in the boarding house, but just write a concurrence once in a while. Johnson ended up becoming the voice and vector of federal power in the sense of national power in many important cases against his fellow members of the Carolina planter elite. In 1823, when sitting as a circuit court judge in Charleston, his hometown, he issued a decision that was the first time a federal judge found that a state law violated the Commerce Clause of the Constitution. It spawned a backlash in Charleston. Cries of nullification 9 years before the Nullification Declaration of 1832, threats against Johnson's life, and he was deeply of Charleston, but he's not the typical speaker in terms of what we expect to see for states' rights in the debates of that period. The other figure is Maria Henrietta Pinckney, much less well-known, born in 1774, the daughter of Charles Cotesworth Pinckney and Sarah Middleton Pinckney, niece of revolutionary generals, signers, and drafters, described by her family as a, quote, woman of masculine intellect. I think that's, well, it's unclear how, well, I think we know how we should take that. I think they definitely meant it of her. She was quite a firebrand in the family, a writer, a planter in her own right, a slave owner in her own right. She never married, and she inherited many of her father's and mother's plantations and slave holdings and enslaved people, and a leading theorist and strategist of the nullification movement. Two of Maria Henrietta Pinckney's male cousins served in the South Carolina Nullification Convention in 1832, but it was her Pinckney mansion on East Bay Street in Charleston that was where the nullification leaders wanted to have their big events, the backdrop of parades and public ceremonies. And it was Maria Henrietta's defense of nullification, titled A Political Catechism, that became one of the core documents of the movement, and it was published in 1830. When she died in 1836 at the age of 62, the Charleston Mercury, edited by her cousin, Henry Lawrence Pinckney, carried a notice directed to the state rights men of 1834 that lauded her heroic patriotism, the strength of her bright character, and the tributes of her cultivated intellect. So I have some slides to show to sort of situate us in these Charleston moments, because I think it's really important to have the visual and the personal as well. So this is a view of Charleston in 1774 by Thomas Leach that's, I think, really remarkable. It's an enormous work. But the statue that's or the building that's in the oval at the right is the Pinckney's mansion. And so it was such a landmark that even in 1774 it would show up if you had a view of Charleston from the east. This is Charleston from above the map, which obviously looks a little bit different from how it looks today. William Johnson's house, that is Justice Johnson, is the red dot on the left, and the Pinckney mansion is over on the right. So they were neighbors. And they knew each other because William Johnson read law with Charles Cotesworth Pinckney in that house where Charles Cotesworth Pinckney had his offices. So Johnson was in the same house as Pinckney, and they were very similar, very close in age. So the moments of this case, though, the one I've mentioned that Justice Johnson heard when he was on circuit, is really one of the, I think, most interesting moments that I discuss in the book, in my own opinion. This was an 1823 case called Elkison versus Delisle. And in Elkison, a free black British sailor named Henry Elkison challenged a South Carolina state law requiring that any free person of color debarking in any South Carolina port be immediately jailed for the duration of the vessel's stay. So this is the famous Police Bill or Seamen's Act. The battle over the South Carolina Seamen's Act involved numerous levels of government, though, and non-governmental actors as well, each with its own views concerning the constitutionality of the state regulations. So just to name a few, and again, to push back or to try to do more than push back on the state-federal binary, here are some of the dramatis personae involved in Elkison versus Delisle. United States Secretary of State John Quincy Adams, United States Attorney General William Wirt, the entire South Carolina congressional delegation, the British Ministry in London, the British consul in Charleston, all involved in this case that started on a wharf on the previous slide on the western edge of Charleston. The British government bankrolled Elkison's suit, and the South Carolina State Attorney General declined to appear in court to defend the act or the detention of Elkison. a newly formed group of planter vigilantes did appear in court, the South Carolina Association. They sent their lawyers to argue on behalf of the South Carolina Seamen's Act, and Johnson noted, sitting as the circuit court judge, which was operating in this context as more or less a trial court, that the state did not even show up to defend its own statute. So here's Johnson, two portraits. Again, he's not one who sort of occupies the pantheon in the Supreme Court because he's so dominated by Marshall, but in fact he was a great character and an underappreciated influence. Also, he was a hothead. There were apparently instances where Henry Wheaton and other members of the bar had to restrain their colleagues from leaping over the table when Justice Johnson delivered some sort of piercing witticism from the bench. He wrote important concurrences in Martin against Hunter's lessee in 1816, Gibbons versus Ogden in 1824, and yes, a dissent in Osborne versus the Bank of the United States. And I think looking at Johnson, who is hardly one of the minor players on the Marshall court, shows what's missing from the conventional stories of Marshall's dominance of the court, because they were clearly intellectual sparring partners, and in many instances, Johnson was more on the nationalist, unionist, federal power side than even Marshall. Here's Johnson's house in Charleston, the distinctive Charleston single house architectural style, situated to take advantage of the breezes. Johnson's house is still there on what is now Rutledge Avenue. I'm sure he would have had strong views about that. And this is the inside of the courthouse, which is still there, although now it's the Charleston County Courthouse, in an interesting federal to local shift. And the courtroom there where he sat and heard Elkison versus DeLisaline in August of 1823 on the second floor of the courtroom. And this is at the corner of Broad and Meeting in Charleston, so it's right in the center of downtown. I really like this slide. These are competing accounts of the decision in the case of Elkison versus DeLisaline. So Johnson held that the South Carolina statute violated both the Interstate Commerce Clause and the Foreign International Commerce Clause. The pamphlets that produced his opinion, one is his opinion, I should say, and the other is the argument of the lawyers who appeared for the South Carolina Association, standing in for the state, recall. And note the caption, Ex parte Henry Elkison, a subject of His Britannic Majesty. That's the one on the left. Justice Johnson had this published when the newspapers declined to publish his opinion. He was always in altercations with the newspapers. But Elkison is described here as a subject of His Britannic Majesty. Then on the right, lawyer Benjamin Faneuil Hunt's version of his arguments, the caption, Ex parte Henry Elkison, claiming to be a subject of His Britannic Majesty, because part of the argument the South Carolina Association made was that Elkison, because he was black, could not even be a subject of His Britannic Majesty, which Johnson held was not the case. So even in the caption, we see the battle over the kind of core of the case and Johnson's view of what was wrong with the state statute. This is a letter from Johnson to Secretary of State John Quincy Adams in 1823, where Johnson describes the South Carolina Association, many of whom were his neighbors and colleagues, as, quote, a self-created society of this place of about 80 or so members who have managed to carry with them the populace and to muzzle the presses. So that's who's standing in the shoes of the state, again, defending the statute. What about the Pinckneys? We don't have a portrait of Maria Henrietta Pinckney, at least I've not been able to find one. We have these portraits, a matched pair by Henry Benbridge of her parents. Sarah Middleton Pinckney on the left, sister of Arthur Middleton, a signer of the Declaration of Independence, and her father, Charles Coatsworth Pinckney, on the right. One is in the Gibbs Museum in Charleston, and the other is in the Smithsonian National Portrait Gallery. So the Pinckneys were the elite of the elite in Charleston and in South Carolina, and these are the parents of Maria Henrietta. A big part of her, I think, sense of herself as a political spokesperson came from that lineage, because her grandmother, even to go beyond her parents, was Eliza Lucas Pinckney, the famous cultivator of indigo. And so Maria Henrietta Pinckney really had a strong sense of herself as having a revolutionary background. And so this is a cartoon of the XYZ affair from an earlier period, featuring Charles Coatsworth Pinckney delivering the key line that became such a piece of American political folklore, here delivered as, cease bawling, monster, we will not give you sixpence. rendered later and hung in a banner on Pinckney Mansion by Maria Henrietta Pinckney as millions in defense, but not a sixpence in tribute. Charles Cotesworth Pinckney always said that wasn't exactly what he said, but it was the gist of it. And his daughter embraced this against the federal tariff. So we don't have a portrait of Maria Henrietta Pinckney. We have one of her mother's family's estates, Middleton Place Plantation, just northwest of Charleston, a huge, huge plantation. And this is, again, part of her background and the planter elite that she's speaking from. And we have her dress in the Charleston Museum. We also have her writings. So this is the manuscript of a political catechism by a lady for her goddaughter. So she frames this tract as the full title, The Quintessence of Long Speeches Arranged as a Political Catechism by a Lady for Her Goddaughter. Yes, it's a political essay, but it's by a lady for her goddaughter, and it's a catechism. So she combines the kind of way in which gentlewomen of the kind of planter elite class were expected to speak, but then delivers this barrage that is even more stridently nullificationist than what you see from John C. Calhoun. Here's the printed copy with signatures from several generations of Pinckney women, each of whom owned it and wrote their name on it. So where was all of this happening? In the Pinckney Mansion, which no longer stands. So the top picture is the enlarged piece from the portrait, or the landscape of Charleston that I showed at the beginning. The bottom is a colonial mansion in ruins, 1865, attributed to Matthew Brady. Now, it wasn't in ruins for the reasons that many of Matthew Brady's portraits and photographs were taken. It had burned in a fire in Charleston in December of 1861. That was a fire that seemed to have been the result of a fire in a warehouse, not the federal gunboats in the harbor, not the reputed insurrection of enslaved people, and also not an attempt to destroy records or anything of the kind. But it was happening right at the beginning of the war, and the remains of the house were photographed by Brady later. Well, today they are neighbors. So this is the churchyard of St. Philip's Church in Charleston. The monument to the left, the obelisk, is William Johnson's monument. I should mention that a few feet away is a huge monument to John C. Calhoun that was put up after the Civil War because it was concealed during the Civil War. And so here's Johnson, and down the block, Maria Henrietta Pinckney, her father and sister, in St. Michael's Churchyard.
Did you take these pictures?
I did take these pictures. So finally, to paraphrase the great historian of early American political thought, Bernard Bailyn, so what? So what do we learn about the Interbellum Constitution from the careers of Pinckney and Johnson? Well, they were simultaneously products and producers of this founding heritage and this idea of the long founding moment. They both believed in the world of politics and had access to it, in part because of their family histories. They drew lessons about shared inheritance. Pinckney's views shaped the nullificationist platform. Johnson delivered these full-throated endorsements of national powers to the startlement of his contemporaries and to many people today. So what did what we would now call federalism look like in South Carolina in 1831, I think is a good place to jump off about and the conversation, or to start the conversation about what it looked like in the interbellum period. It comprised multiple levels of government. It potentially entailed alternatives as diverse as exclusive federal power over commerce or state power to nullify federal law. It was both parochial and nationalistic all at the same time. And it insisted on every punctilio of respect for revolutionary heritage, while nonetheless demanding the power to interpret and to discuss for itself. So it really was at once, I think, both Johnson and Pinckney. So I will stop there and look forward to discussion. Thank you.
Thank you to Michael
for giving me the opportunity to offer just a few remarks about an incredibly rich and lively and engaging new book. The Interbellum Constitution is an incredibly ambitious project. In it, Alison has deftly woven together a series of constitutional debates over commerce, migration, and slavery in the 4.5 decades between the War of 1812 and the American Civil War. The book's main aim is to show us not only the vibrancy and creativity of such debates, and thereby reframe the interbellum era as worthy of our study on these fronts, but to provide us with an overarching framework for understanding what united them. This is a book about the connective tissue that links Gibbons versus Ogden to Cherokee Nation v. Georgia, to the enforcement of laws like the South Carolina Seaman Acts, the Tariff of 1828, and the fugitive slave provision of the Compromise of 1850. For Alison, the key to understanding how these seemingly disparate constitutional debates hang together is appreciating that they were all, in some way or another, about how the pieces of the many governments of the United States fit together. Now, this may seem like a familiar claim. After all, we've been long accustomed to seeing this period as uniquely obsessed with what we call federalism, or the relationship between state and federal government. But in interbellum Americans' lives, Alison shows us, they didn't see state and federal entities as the only, or maybe even the primary actors. They had a much more expansive and often conflicting understandings of who and what might be involved in properly apportioning power. Their federalisms, plural, described a world of legal experience and ideas that has, until now, I think largely been lost to us. Alison has made them visible. There is so much to comment on here, so much to be said, it is hard to even know where to get started. But given my limited time here, I want to focus on a few particular points that I kept coming back around to during my reading. First, while the Interbellum Constitution takes the worlds of courts and legal argumentation that happen within them extremely seriously, the book is so much richer and broader than the usual tour of the era's constitutional history. This is no case-by-case account of the Marshall Court or the Taney Court's greatest hits, and that's that. Instead, Alison has presented us with a panoply of different constitutional disputes. Lawyers and judges, to be sure, but also privileged daughters of South Carolina's leading families, Cherokee political leaders, Western newspaper editors, formerly enslaved men, and all their various interlocutors, arguing about a huge variety of issues across the whole of the young republic, inside and outside courtrooms. What struck me immediately upon reading the Interbellum Constitution, as a historian whose own work follows so closely on this period, is just how right it felt to present Americans at this time as so intensely interested in constitutional argument. Debates about the nature of the Union and the competing, overlapping responsibilities and rights of various levels of government were bursting forth from every corner of the nation. Alison deftly captures this essential, inescapable fact about the young republic. And for me, her work immediately called to mind some of my own recent research into the so-called Missouri crisis, the debate over whether Missouri would enter the Union as a slave state or a free state that emerged when Congressman James Talmadge presented 2 amendments to a bill authorizing Missouri statehood in 1819. I now think of what I discovered as a kind of lost 10th chapter of the Interbellum Constitution. Like the events Alison examines, the Missouri crisis has generally been framed as a national controversy, one that primarily played out in Washington, D.C., at the very highest levels of government. But also, like the events Alison examines, there is an intensely local story to be told as well, about how Missourians themselves responded to Congress's attempts to fix conditions on their admission to the Union. In town resolutions, petitions, and most especially in the pages of the state's newspapers, Missourians in the midst of the crisis, like Alison's actors, engaged in wide-ranging constitutional debate. As in the Interbellum Constitution, this debate even spilled out over into the formal judicial process as grand juries were convened in several Missouri counties to declare their sentiments on the Talmadge amendments. In these various forums, again, as in the Interbellum Constitution, we find Missourians arguing about the meaning of the American Revolution and asking searching questions about the nature of the Union and the proper relationship between the various entities, in this particular instance between the federal government and the territories. Finally, one finds in the Missouri crisis a key figure, in this case Nathaniel Beverly Tucker, who bears remarkable similarities to many of Alison's protagonists. Although he certainly never rose to the heights of a William Johnson, Tucker was also a judge, in his case, of the St. Louis Circuit Court. Like Maria Henrietta Kintney, moreover, Tucker too had a famous family. His father, St. George Tucker, who plays a significant role in an early chapter of Alison's book, was a famed jurist and author of the first American edition of Blackstone's Commentaries. His stepbrother was the brilliant, eccentric John Randolph, who then served in the United States House of Representatives. For me, then, the Interbellum Constitution captures not only the vitality and immediacy of constitutional debates in the era, but many of their key dynamics as well. And she's done so on a vast scale that provides an incredibly useful framework for trying to understand specific constitutional debates like those over the Missouri crisis. One of the key claims of the Interbellum Constitution, as the book's subtitle suggests, is that between the end of the War of 1812 and the American Civil War, federalism, singular, should really be characterized as federalisms, plural. That during the period, federalism revolved not just around the relationship between state and federal governments, but encompassed multiple levels of government, including state and federal governments to be sure, but also the local governments of cities and towns and assemblies of private citizens. And there are many more invocations of the local throughout Alison's book. Local power, local controversies, local connections. But local is a little bit slippery, I think. Sometimes it seems to relate to a much more narrow, much more limited sphere than to the state or region. Alison's actors seem, for instance, to often employ the term pejoratively as a way of exposing the supposed parochialism or private nature of a case. In other instances, however, local seems to be used as a kind of stand-in for state or regional interests. When, for instance, in the Young Republic, slavery is described as a local institution, it seems plain that when using this expression, people were thinking of slavery as both instantiated and protected by state law and driven by a kind of regional interest. So sometimes local means something very narrow, very particular, and other times I think local can be a synonym for the state or the regional level. So I would love to hear a bit more about the use of this term, both during the interbellum era and in Alison's book. So what makes something local as opposed to state or regional? How do we distinguish between them? Is it even useful to try? For what it's worth to me, the local, meaning something more like the first definition, something that distinguishes local from state and regional concerns, does have a particular and important role to play, I think, in the story that Alison's telling. And I actually think her presentation did an amazing job of setting up this particular point. Throughout the Interbellum Constitution, Alison is constantly situating us, tracking the movements of various figures across the American landscape, and through architectural history, getting us to imagine the very rooms in which these arguments are actually produced. What she's written is a kind of spatial history of constitutional debate. It matters to Alison that we see the arguments that she explores as emerging in particular places and reflecting the histories of those places. It matters, too, that the arguments she explores are the products of particular individuals and their preoccupations. This is a structure and a series of narrative choices that I think constantly calls the local to our attention. What Alison seems to be highlighting to me is that constitutional disputes often arose from intensely local concerns and were understood through that lens. The local, that is, animated or activated constitutional disputation. South Carolinians' Seaman Acts, for instance, which were first adopted in Charleston in 1822 and required free black sailors to be housed in local jails when their vessels made landfall in particular jurisdictions, are not motivated by some kind of general abstract fear of slave revolt, but instead by what white Charlestonians thought was a very real slave revolt fomented by a very real man named Gabriel in Charleston itself. Similarly, the Wisconsinites who break the fugitive slave Joshua Glover out of a Milwaukee jail in 1854 are not driven by some general abstract hatred of slavery. On the contrary, white actors are moved first and foremost by the idea that they themselves are being made a party to that institution.
Glover's black rescuers, meanwhile, are compelled to protect an actual person who lived in their actual community from being sent back to a Missouri plantation to live as a slave. This man was presumably a fixture of their community and their friend. But I'm curious to see if Alison agrees. Should we see interbellum arguments about state and federal power as primarily or even just largely activated by local concerns? But for these local concerns, do we get her actors working out the respective boundaries between state and federal power? Is the local fundamentally driving the action in the Interbellum Constitution? I look forward to hashing out these questions and much more in the conversation that follows. Thank you.
I have next. Okay, great. Thank you very much for the invitation, Michael, for the chance to comment on this book, which I feel like I've been in dialogue with Alison about this book since I started on the faculty here. I think it was one of the first times I went to Chicago and commented on what I think was an early version of the book, and it's been really gratifying and exciting to see the project. I reviewed the final manuscript for Oxford, and it came shortly after I wrote a critical review of Akhil Amar's new book after struggling through it. And one of my frustrations with that book, as you can find out if you read it, is basically he claims to be writing about a constitutional conversation that was happening in the early republic, and then he doesn't. I mean, it's about basically, he's like, oh, it was expansive, it was democratic, it had wide-ranging participants, and it turns out that those wide-ranging participants are, in fact, what he calls the Big Six founders, and it's, Madison and Jefferson sitting in a room. And so what was so refreshing and wonderful about reading Alison's manuscript shortly thereafter is this was the book that I wanted to see, that fulfilled all the things that I had hoped for. This was a book that actually it delved into an actual constitutional conversation and really robustly reconstructed it. And did it in all the ways that Alison has already alluded to, right? That really has a capacious set of constitutional actors that are not simply the sort of standard elite white men. There are elite white men who are not the standard elite white men, but people like Johnson who have been neglected. But also a robust range of women, of Cherokee leaders, really that reconstructs in its fullness just how wide-ranging the actual constitutional conversation was in early America. And I think what's so valuable about this, too, is it does so in a way that takes law extremely seriously, that reconstructs legal arguments. This is not the complaint that lawyers sometimes levy against historians, that we actually aren't interested in what people are saying about law. This is a book that takes law extremely seriously, but does something that I aspire to and don't always succeed, I think, in my own work, but that this book does brilliantly, which is it shows why this full reconstruction really matters for understanding these legal arguments. Right? It shows that the arguments that they were having about doctrine during this time period grew out of these very particular contexts and were profoundly shaped by them. And so in order to understand the law of this period, you can't just sort of pluck it out, rip it out, and drop it into current doctrinal debates. You have to do what Alison does, which is take very seriously the historical context, reconstruct it, and show the fullness of the arguments that they were having at the time. And I think one of the huge revelations of this book is also the way that it incorporates the sort of what we might think of as the techniques of social and cultural history, describing the actual physical settings, describing the social worlds from which these arguments emerge, in the context of telling what is a legal story about the history of constitutional doctrine as well. And I think that is really to be applauded. And then the other thing that I just want to celebrate about this book is how valuable and important and significant this book is, because we desperately needed this book. In fact, I feel like ever since I read this manuscript, I've been living in the world of Alison LaCroix, in that there is every, I would say once a month, there is a moment where I'm like, oh, I need a citation to demonstrate just how fraught and contested the idea of concurrent jurisdiction was in the early republic. And up until now, it was very hard to find, there was nothing to fill that place. And, you know, I make it sound like this, the primary purpose here is to put in a footnote to satisfy law review editors, which, you know, is important, yeah. But I think actually what this work does is it really captures this robust debate that was going on in the early Republic, which I think is really essential to understanding the intellectual world in which these cases emerge that has been largely neglected for so long, right? Precisely because, as Alison points out, we so often read these questions backward. We assume that the way that they understood power is familiar to us, when in fact it was not. And so this book does such important work. I mean, I feel like I'm probably going to be, when you go and do the citation count on Google Scholar, I anticipate being the cause of at least 100 or so of those citations down the line. Okay. So, so Alison, at one point, when Alison and I were emailing about this book, you know, I think Alison and I share so many methodological assumptions and approaches. But there are points at which we disagree, and I think at one point she described me as a friendly interlocutor to work through these questions. And so, because I think disagreement is more interesting for an audience than simply praise, although I do want to sort of heap the praise on here. I did want to ask a little bit about what I think is, for me, the outstanding question, which is the sort of question about pluralism, which is not a term that I think you use directly in the book, but I think for me frames a lot of the way that I think about federalism and when I've written about federalism. So you talked a lot about the risk of sort of reading backward from the present. But because I'm a historian primarily of the late 18th and early 19th centuries, I tend to read this period forward, right? So I tend to see it in light of the period that I study intensely. And I think what's striking to me is that the world of the 18th century, which is really, I think, in imperial world in the many connotations that term has, is this richly pluralist world in which power and sovereignty, which is the term that they also use at this time period, is intensely fragmented, divided, shared in all sorts of complicated ways. And so when I look forward to the interbellum period, what I see is actually something of the way that federalism is actually, to borrow, I think, Robert Cover's term, jurispathic. In other words, federalism, although we think about federalism often as a source for greater pluralism, in fact, over time, federalism came to diminish pluralism. And I think this is maybe particularly striking in the chapters on the Cherokee Nation, which I think were exceptionally well done and rightly put this episode, this contestation, at the center of a lot of the history of federalism. But I think when you look from the perspective of the late 18th century, what is apparent is how much has been foreclosed rather than expanded for the Cherokee Nation and other native peoples. So you talk about the way that they envision sort of fractal federalism, right? That they sort of can fit within the Union, not as a state, but as sort of autonomous entity under the scope of federal power. I think there's two things that are striking about this. One is just how different that is from the late 18th century, where Native peoples stubbornly contested the argument that they were under federal sovereignty at all, or the sovereignty of the United States. That when the federal government advanced that perspective, they pushed back by insisting that, in fact, they were fully autonomous nations that were outside any control, whether from the federal or state governments. And so even the acknowledgement of U.S. sovereignty was, in fact, a concession. And I think something of a loss for Native nations. I think it was a gambit that they had to, concession that they had to make in order to navigate the world that was being created for them. And so I think the other parallel that unfolds is that actually they sort of, in some ways, lose the battle to defend fractal federalism. Of course, this is most clear in the fact that the assertions of state jurisdiction over them are effectively unchecked by the U.S. Supreme Court and end up in a deportation that very visibly means that state sovereignty is now going to be supreme within these southern states that were stubbornly insisting on it. But even the defense of native sovereignty and autonomy such as it comes is very much about the defense of federal authority and sovereignty, right? That if you read Worcester versus Georgia, which is something I've had to do a lot lately, it ends up being a case about defending the scope of federal authority and prerogative as much as it is about defending native autonomy. And so, I feel in some ways that and again, I think this is just a matter of perspective and where you sit, but for me, what I see is a world in which, although there is still tremendous amount of space for creativity, for plural authority, for diverse arrangements, it is a world in which an ideology of federalism is actually increasingly foreclosing those spaces. So I'm curious how you think about that story and how you think about pluralism in this story, right? And how do federalism and pluralism intersect? And Annie alluded to the sort of spatial imagination. And I think one of the striking things about this period is if you look at the maps that they are producing, they clearly embody a particular kind of spatial imagination, right? A union comprised of sovereign states, neatly divided in boxes on the map, and then maybe some federal territories out there. But it is a spatial imagination that I think forecloses many of the sort of creative plural visions about power, about sovereignty that a prior generation had sought to defend. So that I think is my big outstanding question at the end of the book, but I don't want my friendly interlocutory question to detract from what I think is the really overwhelming achievement of this book, right? Which I think just quite embodies so much of what I think is a model for how we all should be writing constitutional history going forward. So I think I'm really excited to see this book, and I'm really excited to just bump up your citation counts, because I'm going to be using this a lot. I think I'm already at 4.
All right. Perfect. Thank you, Greg.
So, Alison, thank you for that talk. And I just wanted to tell folks, the book is every bit as interesting as that talk was. So, and that's a high compliment. But I have a bit of a confession, which will tell you where I'm coming from. So, when I first read several chapters of the book, it came after I heard Alison speaking at a conference here in the spring. And I knew that I was working on an amicus brief in the Supreme Court on behalf of the Chamber of Commerce in a case called National Pork Producers versus Ross. And I could tell even from her brief summary that this book was going to provide the thinking that I needed in order to write this real-world legal brief, and indeed it was extremely helpful to me in that, and that moves me to talk in a somewhat different vein. I'm going to talk as a lawyer, as a constitutional lawyer and constitutional theorist, rather than as a historian. But one of the things that we've been talking about here, especially with Jonathan and Jack Rakoff and others, and Greg and Alison, is what are history and constitutional theory doing together? And I'd like to talk about why books like this, not just Alison's book, but books like this, by which I mean books that provide a detailed account of constitutional developments, not at the beginning and not recently, but in between. What is their role in constitutional interpretation? Not just as a matter of interest, but as a matter of actual constitutional argumentation. And In talking about that, I'm going to talk about the new court. I think we are at a time. I think most of us recognize that we're at a time when a lot of assumptions are being rethought. It's a very different new court, and one of the things that's different about it is that it recognizes, not for the first time, but I think much more frequently, and much more in a lot more different areas of constitutional law, it refers to the authority of what it calls history and tradition. And I think by history and tradition, what the court means is the things that happened between the founding and the present, at the time in between. That is to say, they're talking about the very type of legal history and constitutional history that Alison is writing about. But it's not just the justices. I think that there has been a kind of convergence in the last several years between what had been kind of the two poles of constitutional interpretation, which we might call originalism on the one hand and living constitutionalism on the other. Just for those who don't know your isms, briefly, originalism is the view that the Constitution should be interpreted in light of our best interpretation of what it meant to the people who enacted and ratified it. That means 1787 for much of the Constitution, but 1868 to 69 for other important parts, and then there are a few others as well. And living constitutionalism is roughly the view that indeterminate language in the Constitution should be interpreted in light of contemporary needs and understandings as seen by the judiciary. And those are obviously polar opposites, right? But I think that there has been a certain convergence in recent years. On the originalism side, I think it is becoming, as more people are trying to do originalism, and with a little bit less guesswork and a little bit more history involved, what I think it is becoming increasingly evident that on many questions there is just not enough history to answer or provide even much guidance about the particular question, and so the originalism needs to be supplemented somehow with something else. And I think originalism is beginning, instead of being the view that in every case the answer is what they thought, right? I think increasingly the view is the constitutional interpretation should not contradict anything that we know about the original meaning, but that there's going to be a lot more coming from elsewhere as well. Where will that be? The leading originalist answer is that it comes through what a lot of people in this camp call liquidation. This is the term that James Madison used in Federalist 37, where he says that there are a number of portions of the Constitution that are necessarily vague and that we don't quite know what they mean, and that the meaning of those will be determined and fixed, by the way, is his word, through and liquidated through a series of discussions and decisions. In all likelihood, decisions sounds like precedents, judicial cases and decisions. Discussions sounds like constitutional disputation in other arenas, such as what Alison has, brings so powerfully to life in her book. And so the idea is that if that is a way in which Madison and others, Hamilton used the same term, envision constitutional interpretation to proceed, well, maybe that's maybe how it should proceed from an originalist point of view. And so instead of being all about the founding or Reconstruction, it becomes about those things, yes, but also about the progress of constitutional discussions, argumentations, decisions over time, including the entire antebellum Constitution. Well, from the living originalist, I'm sorry, the living originalism is the name of Jack Balkin's book, which I'm actually teaching in my seminar very soon. So sorry, so living constitutionalism also, I think, has been revising their sense. There have always been a certain number of flavors or families within both of these camps. They are not just one view. But among the living constitutionalist camp, there's a one wing of that has been most famously associated with Ronald Dworkin, is the idea that if there's no real answer to be gotten from text and precedent and so forth, what the judge ought to do is give the philosophically correct answer to make the world as good a place as it can be, even when that means imposing on the nation one of several reasonable, this is Dworkin's own term for it, reasonable alternatives on difficult moral questions. So it's a kind of judicial supremacy. But I think that living constitutionalists have tended to sour on that point of view of late, partly because it's so judicial and elitist, but partly because when you look around the court, or I'm sorry, around the world at the courts, and they're not all your friends, you may not want to advocate a style of constitutional interpretation where, where they, Amy Coney Barrett, Brett Kavanaugh, Sam Alito, you can name people all over the country. We may not want to advocate a view that they get to give the answer that they think is the best. And so I think living constitution people begin to look around for a source of authority other than just their own opinions about things. And where do they seem to be looking? Well, how about the actual practices in the constitutional republic? This is what John Rawls seems to be looking toward in his idea of reflective equilibrium. And so you look at the actual practices and you look at your theories and you sort of try to come up with a theory of constitutional meaning which takes into account the actual developments on the ground. And so we increasingly see justices like Elena Kagan making arguments based upon not just, this is a moral claim, but claims about constitutional history. And constitutional history comes, of course, in two different forms. There's the originals, which Kagan is perfectly happy to argue about, but there's also the over time, the sort of thing that Alison is writing about. And so it is my impression, I could be wrong about this, but it is my impression that these two previously opposite camps of constitutional interpretation are both converging with the common element being that they are both paying a whole lot more attention than they used to the development of constitutional meaning over time. And each of these, so if you think about it, there really are three different possible points at which decisions about constitutional meaning are taking place. There is the founding, and I think the theory behind that, why does that have authority? The main theory is that some version of constitutional positivism, that the Constitution was actually made for a reason, and that reason should govern. Or I'll just read a quick passage from Marbury versus Madison, which takes this view, where Chief Justice Marshall said that the people have an original right to establish for their future government such principles as, in their opinion, shall most conduce to their own happiness, is the basis on which the whole American fabric has been erected. and he goes on to say that these principles are fundamental, and as the authority from which they proceed is supreme and can seldom act, they are designed to be permanent. So the principles of the original Constitution designed to be permanent, that's why we look to the evidence at the founding. Well, why do we look at the present? Well, the present reflects current democratic will. We see what Congress is passing. We see what various state legislatures are passing. That, and we are a republic. We're a constitutional democracy, and what these democratically chosen bodies are doing, therefore, has a certain authority. This is associated in constitutional practice with what I would call, and many people call, judicial restraint. That is, judges should be very careful when overturning the acts of the Congress or the democratic legislatures. And on the living Constitution side of the ledger, this is looking more and more important, right? You see much more emphasis in the opinions of people like Elena Kagan on, the court should not be so arrogant as to overturn things that the people's representatives have been passing. Well, so that's the beginning and it's the present, and they both have a certain democratic feel. What about the middle? I think the court and the practitioners are actually struggling to explain what the actual theoretical rationale is for why we should care about what they were doing between the War of 1812 and the Civil War, or what they were doing, between the turn of the century and World War II, or whatever it is. Why is that authoritative? It doesn't seem to correspond either with constitutional positivism or with current deference to democratic decisions. And I think the answer can be gotten partly by, Alison of course, isn't giving a theory here, but I think when you see the force of the history, you begin to appreciate this. Part of it is a kind of Burkean understanding, which is very similar to common law understanding in our legal system, that the passage of events over time, multi-generational change is both a more reliable source, but also closer to the identity of the nation than particular decisions at particular points. So if you really want to know what are the values and principles that animate the United States, don't just talk about today, don't just talk about the big six, and as Greg mentioned, but you take the whole thing and warts and all, I might add, not just not a Disney-fied version of the whole thing, but over time, and that this is going to give a better sense of what America really stands for than the alternatives. And the best thing may be to be able to bring all these three things together, like not to just do only originalism, not to do only judicial restraint, not to do only the Interbellum Constitution, but to make them all fit. But as Alison began her talk by noting that this was her period is a gap. There hasn't been much work done there, and there are other gaps too. We have focused in constitutional history and backward thinking on the founding and on a few other key moments like the New Deal and maybe a Reconstruction. We've left a whole lot out, and in order to do this history and tradition method responsibly and accurately, we need to know a whole, and by we, I mean lawyers and judges, not just historians. You guys will take care of yourselves, but lawyers and judges need to know a lot more about what happens during these intermediate and interim periods of constitutional development, because most of us have not been taught much about it. So we need to read the books, and when we're reading Alison's book, we shouldn't just enjoy her luscious accounts of Henrietta Middleton Pinckney and so forth, but we ought to think about the national pork producers too, by which I mean, how do these various ideas that are developing in her story actually bear upon our thinking about the Constitution today? So, that's why I recommend this book. So we have time for questions, right? You want to MC this?
Yes. So I'll turn on the mics.
And we do ask that you come to the microphone so that people, while listening to this recording, will know what the question was.
Hi, so I'm Ethan. I'm a regular of this talk, so thank you so much for the interesting talk. So my question for the panel is, what part of federalism is today up for grabs? I mean, it's interesting that we have the history and everything, but looking 10 years from now, I like what Michael said about Elena Keegan. She mentioned that into Section 230, that she wants to say we are experts, but even that, what they decide on Section 230 would affect everybody. Why should California live through the thinking about these people who are clueless people about the internet when we are here? I work in high tech, we know about high tech. Why should actually abide by that? So the question in a larger sense is, what are the parts of federalism that are up for grabs looking 10 years into the future? Thank you.
I mean, that may be in my bailiwick. Federalism is always up for grabs, and it's usually up for grabs for different reasons. What I think is the thing that is a little bit different about our times, and that is creating a new federalism, is the associative sorting that's happening between the left and the right, so that we have red states that are really red, we have blue states that are really blue, and a few purple states, but not that many. And this leads to conflicts between the states, as in actually the pork producers' case is all about California's effort to regulate the entire pork industry nationwide. It's a conflict between California and places like Ohio where they actually raise pigs. But also between the states and the national government. And every time the presidency flips, these conflicts flip. So when Trump is president, the Democratic attorneys general were suing him constantly. So, and now that Biden is president, the Republican attorneys general are the ones who are suing constantly, and this is a new phenomenon. I don't mean zero in the past, but for the major constitutional cases to be in the form of state attorneys general suing, often on the very thin basis of standing, but bringing their cases. This puts Madison's idea that the states will be the locus of organizing resistance to federal tyranny in a very interesting and now hyper-polarized partisan light.
My question is for Alison. I think I'm inferring that what we now think of as originalism was not a dominant mode or theory of constitutional interpretation in the period that you're talking about. And I'm curious what kinds of approaches to constitutional justification were variously used in that area?
Yes, I definitely think it's the case that they were not, excuse me, originalists, and we have accounts from Madison where he explicitly basically says, in terms translated for today, I'm not an originalist. So he lived for a long time, and people would write him letters. And so at one point in the 1830s, excuse me, the early 1830s, President Jackson and Secretary of State Van Buren wrote to Madison, and they said, hey, we love what you did with your veto of the bonus bill when you were president back in 1817. We'd like to use that for a veto. I think it was the bank, yeah. And so I was thinking, is it the bank or the Maysville Road?
I think
the
it's
bank.
the Maysville Road.
Veto. But they write to Van Buren on behalf of Jackson, writes to Madison, and they basically say, let us make sure we understand the basis of your veto. It was that Congress could fund these parts of internal improvements, but not these parts. And we have that right. And by the way, could you draft an amendment for us? Because why not? You're just at Montpelier. What else are you doing? And Madison writes back and basically says, you don't understand anything. I think of it as the I'm James Madison and you know nothing of my work moment. Where he basically says, like, nobody understands what I meant. That's not exactly what I meant. And you're kind of waiting. I was reading these for the big moment of, and so, something needs to happen. And instead, he explicitly says, the meaning of the words as they are in the mind of the person who wrote them, meaning himself, doesn't really matter anymore. It's they're susceptible of interpretation by generations of other people, and he's sort of looking at them having gone beyond his control. And he doesn't, and so Van Buren and Jackson sort of say, like, oh, well, we're kind of embarrassed then, should we amend or should we restate what we were going to say? And he says, no, they're independent of what I intended them to be. But what did they look at? I mean, one thing I've found fascinating is the amount of constitutional interpretation and argument that was going on in places that we don't think of it anymore or see it as much. So in the executive branch, the Attorney General at that point was like the Solicitor General, the Attorney General, and the Office of Legal Counsel all in one. And he was constantly pulling out volumes of like Vattel and Montesquieu, and also treatises from Anglo-American law. So I think they had a much richer body of sources that they viewed as authoritative, in addition to precedents and other things, including Law of Nations treatises and others. So I think they didn't see it in quite the same way. And then you get Marshall saying things. I love his argument for the bank in McCullough, which if you read it is the most terrifying nationalistic vision, because he talks about armies being marched across this continent, revenues will be collected. It's like, boy, why don't you give Maryland more reasons to dislike the bank? But he's using that all as a positive vision of why you should have the Bank of the United States. And so I think you also see these arguments about sort of, purpose and kind of constitutional ethos that they make also.
Sorry, we're out of time.
Well, and I didn't know we were out of time. I was too gripped. So let me just ask you to join me in thanking Alison in particular. And Ann and Greg for their comments as well. And I will just remind everyone the next Constitutional Law Center event will be this coming Monday. Jennifer Mascott will be talking about the officers, which is there's a number of constitutional arguments right now having to do with officers, but through ratification. So this is going to be a talk both interesting from a sort of common law theory point of view because of the emphasis on ratification rather than other sources, but also ripped from the headlines and administrative law controversies. So please join us next at 5 o'clock here next Monday.